Nice to see everyone. I hope the rain for the 5 days of the past week did not result in 500 roof leaks for your condos out there. I know there are a lot of association managers dealing with crazy roof leaks, but that was some rain. But we still kind of dodged the bullet on the hurricane, so we're still kind of appreciative about that, right? God bless those people in Central Florida who got whacked pretty bad. So we'll see what happens. And I think, just as a footnote, I think that we're going to see probably some insurance policy and rating impacts from that, even though we're not in Florida. But typically, large storms like that will impact insurance rating, especially in multi-unit housings like condominium associations. So hopefully not, but typically that is what happens. You know, we see that in the industry. Thanks for coming, everybody. As you know, these are for educational purposes only, not legal advice. This does not constitute an attorney-client relationship, and nothing will be held in confidence. So no confidential information here. We do have dogs of the day. Let's see if you could put them up there, Eileen, or I can too.
I got it.
You got it. Okay. So the dogs of the day today are Jameson and Miso. Really nice dogs. I guess puppies, pretty much. So Jameson and Miso, they are owned by Bonnie Bertan, who is the owner of Association Advisors. I think a number of you do work with Association Advisors. They're a management company based out of Freehold. So thanks so much, Bonnie, for sending them over. Beautiful dogs. Thank you for sending them. And so we're going to go kind of quickly today. So the first issue is signs on common property. Why are we talking about signs on common property? Because this is the silly season, right? So a month from now, almost exactly, we are going to be at election day, midterm elections. All the talking heads on TV have been torturing us already for the past year about all the politics. And we're going to start seeing the signs, if you have not seen them already, on the lawn, on the garage door, on the berms, in the planting beds, et cetera, et cetera. So, you know, that's a good thing in a way, but it's a really annoying thing in another way. So it's America. So God bless America. We do have the right to free speech. We still have the right to free speech, and people generally can say what they want. So the big rub in community association world and condominium world was, well, wait a second. How do you have free speech rights on the association's property? You know, they're kind of conflicting rights, right? So it's association property. The association's governing documents say that they can regulate it, they can prohibit signs, they can limit signs, et cetera. And our governing documents say no signs. What's up, Mike?
Sorry.
So we're talking about signs on common property and signs on units. Why do we have a difference there? Because the New Jersey Supreme Court, and this, for those of you who probably have spoken to me in person about this, so the New Jersey Supreme Court basically says that New Jersey values free speech, freedom of speech, freedom of expression, in many respects, not all respects, still respects property rights, but a little differently than the federal Constitution does. So the Supreme Court of New Jersey has indicated that the New Jersey Constitution gives broader protection for free speech rights, even in the case of privately owned property and private conduct, right? So typically, the federal Constitution applies to restrict the government from doing things or limiting people's rights. But in the case of New Jersey, the New Jersey Constitution has been interpreted in a way that allows the Supreme Court to regulate and give, we'll say, owners, residents, et cetera, more rights than they might otherwise have with respect to private property. So how does that impact us? The cases really grow out of a number of situations. For those of you who don't remember, the kind of the early case was Princeton University. So when they look at free speech on other people's property, a lot of times they look at it's called the Schmid case, SCHMID, versus Princeton University. And that was a case where there was a gentleman speaking and giving speeches on Princeton University's property. Princeton University threw him out, and I believe they prosecuted him. And the court said in the Schmid case, well, wait a second, this doesn't make sense because Princeton University regularly allows its campus to be open for speech, right? So people come there, people protest things, et cetera, and the court said, wait a second, you can't open your campus to speech, but then selectively throw people out because you don't like their message, right? So that's content. That's content. You don't want to regulate content, right? You can regulate time, place, and manner. In today's agenda, you see time, place, and manner. What is time? Time is when the signs can go up. For how long can the signs go up? So a lot of associations have sign resolutions that say you can put signs up for Christmas, you can put banners up for Christmas, or you can put banners up for Easter or other religious or other holidays, but they must be taken down within a certain time frame. You know, you can't have a Christmas sign up in July unless it's the weekend of Christmas in July, or a boat parade. So that's time. Place, where can they be placed? The associations do have a right to regulate where they're placed. Where does this case law come out of? This comes out of the Twin Rivers case. Most of you are very familiar with Twin Rivers, which is right off of Route 33 over there in by Heightstown. Very, very, very large community. And the Twin Rivers case, in a kind of odd opinion by the New Jersey Supreme Court, said that Twin Rivers was not violating the association members' rights to put up signs because the association allowed one sign, I think it was 3 feet by 3 feet, in each person's planting bed, and also allowed one sign in each unit's window. So not each window, I'm sorry, but in each unit. So they were allowed to have one sign in the unit itself and one sign in the planting bed. And the Supreme Court said, that's enough. And then the Supreme Court, New Jersey Supreme Court, went on to give an analysis of really what you need to look at when you're looking at signage. And then what they said is, although basically Twin Rivers does not violate it, this should be the test going forward with respect to signage. The nature, purposes, and primary use of the private property. What they mean by that is generally the normal use of the property. So in Twin Rivers, as opposed to the Princeton University case, and there are a bunch of shopping mall cases too, the Twin Rivers community is a private community. People are not invited on their property. Unlike commercial property, they're not invited to come and hang out at the mall. They're not invited to come and hang out on Princeton University's campus and speak, etc. So under the Twin Rivers case, the nature of the property was residential and private. The second point that the court says you have to consider is the extent and nature of the public's invitation to use the property. So again, Twin Rivers was successful in that because Twin Rivers never invited the public in. This is a real issue, though, for associations, right? Because there are some associations who say, and this is not with respect to signage, but hey, we want the Democratic committee members to come in and speak at our community. That's dangerous, right? Because once you start having people from the public invited to speak in your community, two things can happen. Number one, it can be opened as a public forum. Number two, you can have a balancing, right? In that the association, if they have the Democratic committee members come in, they would have a very strong chance of being compelled to have the Republican committee members have a right to come in. So you have to be very cautious from an association standpoint of inviting in members of the public to speak, because it may open the door to other things, right? You may say, hey, we want to have a forum as to the Republicans and the Democrats and have them come in and speak. Can you do that without having if a Green Party representative says, wait a second, no, I want to speak too. I want to speak as well. And you say, no, we all we wanted was the major parties here. Well, we're going to have the Communist Party here speaking as well. We don't want that either, right? So you just have to be very careful about opening the door. So the analysis of Schmid is number one, you look at the nature of the property. Almost all of our associations that I work with, the nature is residential and private. Number two, the extent and nature of the public's invitation to use the property. Again, virtually every association that we work with, it's private. We don't invite the public to come in. We don't invite outside politicians, et cetera, to come in. The next topic, a point that the courts look at is the purpose of the expressional activity undertaken upon the property in relation to the private and public use of the property. So really what that's talking about is if your people are putting up signs, what are the signs about? Are there signs that say, hey, buy Tupperware? Are they signs that say, buy my vacuum cleaner? Or are they signs that say, I'm a great stockbroker? So that's a problem, right? Courts, even though they don't always admit this, tend to distinguish between commercial speech, which would be buy my vacuum cleaner, and political and religious speech. So generally speaking, in American jurisprudence, the courts, again, whether they admit it or not, give greater weight to political speech and religious speech than they do commercial speech. So the courts will look at what is the purpose of the speech. In addition to that, the Twin Rivers case added a second, well, I shouldn't say a second, a fourth element to the Princeton University test. So it had 1, 2, 3, and then 4 is the balancing of the expressional rights and the property rights. So the court has to look at the first 3 factors and then kind of balance. Does this make sense? Does this make sense in the context? Is this a fair and reasonable application? So that's how we get to signage on the common property. And for those of you who've looked at this issue in the past, for different reasons, this basically applies to both signage for, generally now for in a political context, candidates for public office, but it also would apply to candidates for association office, right? So if someone says, vote for me for the board of Beaverbrook Club, blah, 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 they can have a sign that says that. It does not just apply to protect candidates for public office. And then we got into the Mazda Brook case. For those of you familiar with Mazda Brook, Mazda Brook is further up north. The Mazda Brook case was a little bit different because unlike signs on the common property, the Mazda Brook case involved a matter where a gentleman was running for public office, not association office, and he put a sign in the window of his unit for himself, advocating his own candidacy. And the association said, wait a second, we have a rule that says not on your unit, not in your unit. And the court there went on and basically extended the Twin Rivers rationale and said, wait a second, you have to give reasonable ability to communicate your political views from your unit. And the one sign was enough. So the court there held that the gentleman was able to put up a sign for his own candidacy and subject to reasonable restrictions, right? So again, it goes back to time, place, and manner. Can you have a sign up for your candidacy for township committee for 5 years? You know, you're running for office, you're not successful, but you leave the sign picture of yourself, this giant picture in your window for 5 years. No, generally not. That would not be reasonable. Place for the sign display. So again, I think associations would be safe to say, as long as it was reasonable, you can only put it in this window, in one window in the front of the house, whatever. So that's where it can be located. Manner of sign display. We talked about this before. What about the neon flashing sign, right? No, you're allowed to do manner as well. So you can't have the neon flashing sign. You can regulate the manner of display. So time, place, and manner, that goes for signage basically within the unit and without the unit. So as I said in the Twin Rivers decision, the court there, the Supreme Court, seemed to signal that it was reasonable for the association to restrict to one sign in the unit itself and one sign in the planting bed. Things get a little more complicated if people want to have 2, 3, 4 signs. And it depends what the association wants to do with that. I generally am very much in favor of free speech. You all know that. So I tend to lean towards at least being flexible with even with the number of signs, so long as the sign size, place, location, etc., is complied with. So the $1 million question, right? Everyone knows the $1 million question on signage. What about this? Let me see. Let's see what I can see here. I'm going to try and share screen. I haven't shared screen in a while. So just to offend everybody, hold your eyes if you're offended. There you go. And I covered both parties, right? So everyone could see that, right? Everyone could see that. So this example right here, I was not able to find out where that sign came from, but it's in somebody's front yard. And all of you, and I know I have seen in a number of the communities we work with, signs very similar to this. On the top picture, this woman was very passionate, as you could tell, and was not hesitant to spend money on banners and signs. I think you could tell how she feels about President Biden. So, as you can tell about him, this person feels about former President Trump. These people were not shy. So the question always comes up to us, what about profanity? What about profanity? Fran, this is insane. This lady up top here, and by the way, this was in a school zone. This was in a school zone. A lovely lady, I'm sure. So the municipality and the municipal prosecutor filed charges against the woman in the top picture. The municipal court judge entered a verdict against her, and she was fined to take down the signs because of the profanity. And she appealed it. This was, I think, in 2021. Yep. So she appealed it. It went to the Superior Court. The American Civil Liberties Union came in on her side and supported her in terms of the use of profanity, whether you agree with that or not. And she won at the Superior Court level. And the Superior Court overruled the municipal court judge, who I know who's a smart guy and a nice guy too as an attorney. And he was overruled, and Superior Court said, nope, you can keep them up. And the township did not pursue it anymore. So how do we deal with profanity-laced signs like this? Is anyone a fan of these signs? No. Nobody I know, except the people with those signs up, is a fan of those signs in their community. So how do we deal with them? The most successful way, this is going to sound strange, right? And maybe like a little cheesy, but the most successful way I've dealt with that is if the manager or if somebody has a relationship with the person, actually ask them nicely to take down the profanity-laced signs. And I've had some success with that. Not as much with this is a violation, because I have found that those people will dig their heels in. I have rights as an American, regardless of what side of the political spectrum you're on, when in fact, most of us, we'll call it the silent majority, are somewhere in the middle, right, of the two extremes. And I have found, generally speaking, if you can get somebody who has a relationship with the person, whether it's a manager or a board member, what have you, is the people who are asked nicely to remove the profanity-laced signs, to take them down, as long as they're not ordered to take them down, and as long as the compliant signs are left up. So that's the content. You don't want to, that the profanity-laced signs are extreme examples, but you don't want to get into trying to regulate content. The reason I say that is it's inappropriate to regulate free speech content. And we have seen that a fair amount in associations where they'll say, like, so for example, very hot political issues or social issues or philosophical issues. So we see that with both philosophy and religious signs. This especially has been an issue recently with the, for want of a better word, we'll call it the pro-life versus anti-abortion. I know these people massage, both words on the on either side of those issues. But the fact of the matter is, associations should not be regulating the content. If someone says, that I have this is the way I feel about abortion, or this is the way I feel about abortion, regardless of their opinion. The association should not be in the business of determining what the content of the sign is, right? So you have to be very cautious about that. I have had some associations that, with all good intentions, they have said, we want no signs that in any way involve religion, because we feel that it will add adversity and be divisive in the community. Well, that you may feel that that's a good intention, but the fact of the matter is you just cannot regulate that way. That is content regulation. People are entitled to their opinion, especially, like I said, in the United States, where political speech and religious speech is very, very highly protected. So you have to be very cautious with that. We had a couple of questions. Let's see.
Hey, friend, what are your thoughts on limiting the time frame in which political signs are permitted? You know, a month before the primary, for example.
Right. So
a month
right
before the election.
So yeah, I think a month is fair. You can also do other things, like I don't have an example with me. You could also do other things that say the condition of the sign, right? So you could say political signs a month before and perhaps a week or two after the election. But you could also do things that say the signage must be kept in a good repair, must be maintained properly, must not interfere with the ability to cut the grass, right?
Now,
Sorry.
I was just going to say, do you think it would be permissible for the signs that you just showed, which are really just throwing out my political belief versus a particular candidate, but categorizing that as a political sign for the purpose of limiting when they can be shown or flown?
I think in the current, unfortunately, in the current political environment, I think it would be tough to limit them from a time standpoint, right? Because those signs that I showed before are unfortunately seem to express a permanently entrenched view of the world from both sides, which again is unfortunate. But so I'm not sure. I'm not sure. So historically, we would say like a month before, 2 weeks after. But in today's political environment, I'm not sure you could say to somebody, take down your Trump sign or take down your Biden sign, because I think it's fair to say that those type of signs at the moment say more than please vote for Joe Biden for president or please vote for Donald Trump for president, right? They have become almost kind of philosophies unto themselves, which is bizarre to me. But I think you'd have a hard time with timing issues right now, Mike. I think it's a good question, and I don't think it's an issue that you want to go to war over. I would, however, so in the example, I won't put it back up, but the example of the woman with 1, 2, 3, 4, 5, 6, 7 Trump signs, definitely I think the association would be fair in limiting the number of signs, limiting the placement of signs. So that is not an association, as you could tell, but I don't think any association would allow stapling signs to a stockade fence in the backyard, or stapling signs to the privacy fence along the side of your townhome. Although, again, I represent, some of you may be on the call, some of you I represent where people have put them up on their garage doors, these giant signs on their garage doors, which say F this one or F that one, which is ridiculous and really, I think, reflects poorly on the association. But people do it, and we have to try and make a call on how to deal with it. The one thing that people should remember, even though I'm very, 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 very in favor of free speech, and it is the First Amendment for a reason, because that without free speech, you can't do much anything else, right? There are limits on free speech, right? There are limits on free speech, even in the U.S. So, true threats, that's not protected free speech, right? I'm going to kill you. That's not protected free speech, right? Incitement to imminent lawless action, right? So that's the classic yelling fire in the movie theater. right? You run into a movie theater, oh my gosh, there's a fire, everyone runs out, and you're creating a riot. Or you're in a crowd after an Eagles game or a Giants game, and two guys start pushing each other, and you're yelling in the background, kill him, kill him, kill him. No, that's not free speech. You're inciting a riot is what you're doing. You're inciting imminent lawless action. So there are limitations on speech. We don't see that very much in the sign context. Most of the stuff that we run into in the association world and that you run into out in your world is the signs on the berm, the signs that have content that offend people. And where things get really strange is, unfortunately, some board members will take things into their own hands. And I don't know if any of you have, but I've seen board members drive through a community, taking signs down, throwing them in the back of their trunk. So you as an association are going to get sued for that. And the association will lose that case. You can't take people's signs. You can't just take them down, generally speaking. Even, if you speak to us or you speak to your own attorney, if there's a self-help provision in the bylaws in terms of violation, you still have to talk about each particular case. You don't want to be in the newspaper saying someone claiming that you took down a Joe Biden sign or took down a Donald Trump sign, although that went on regularly during the last election cycle, and I imagine it's going to go on again during this election cycle. So just be careful, because I have had several communities where residents were driving around taking down political signs. You want to go ahead, Mike? In terms of, you want to grab that first question?
Sure, yeah. So the first question says, how long can they keep the signs up for? And I think it's a good question. I think you can more or less categorize signs, sports signs, right? So football signs can stay up during the season, 2 weeks after. There's the general guideline of reasonableness here. So whatever that really means. Same with political signs. That's why I was bringing up the political signs that are just more or less a declaration of who you are as a person versus vote for this individual. But if it's truly vote for XYZ for mayor, I think it'd be permissible to put a time frame of a month before, 2 weeks after the election, for sale signs while it's up for sale, so on and so forth. So you can categorize the signs for the purpose of incorporating, content neutral time frames for those categories of signs. If that makes sense.
Thanks, Mike. So Jim Maggot says he loved the bird bath that was in the middle of all those, those hate-filled signs, which is nice. Love your neighbor, F everybody, right? A little bit of a disconnect, So people, as you know, people right now are a little zany, and I would bet money that woman, whoever she was a little zany. So thanks, Jim. I like the bird bath too. Do I understand we now need to allow signs like Black Lives Matter, American flags, political signs, and can't send violations to remove them, even if equitable? So I'll try and parse that out a little bit. So there's a very odd law. There's a very odd law at it's at the state level, and it's also at the federal level, that protects display of the American flag. And it basically says, I hate to say this, but it basically says that associations can't regulate display of the American flag, which I think it's anti-American to say that, right? Because associations do have property rights. Associations do have rights to do certain things. And I think a law that compels associations to, and I love the American flag, don't get me wrong, but that compels associations to be totally hands off of American flags, even in terms of time, place, and manner, is a bad idea, and it infringes on other rights that associations have and that property owners have. Nevertheless, the statutes protecting display of the American flag are extremely broad, and most definitely, before you ever send anyone or give them a violation for display of the American flag, speak to your attorney. Speak to your attorney. And there are, just so you know, there are several cases across the United States where homeowners in associations have pursued test cases based on the American flag. So they'll be in a single family home retirement community, and they will put up a 40-foot flagpole with the American flag on it, just to test the association just to keep Jim Maggot awake at night, right? Keep him on his toes. I dare you to take down my flagpole, Jim Maggot. So it's you will have those people, and if that does happen, it's very delicate. There are people obviously who, especially people who have had military service, who rightfully feel very passionate about displaying the American flag, and rightfully so. But you have to be very, very cautious because the statutes are very, very protective, even when people do things that seemingly make no sense in the context of a community association, right? So be very careful. Now, back onto Black Lives Matter and political signs, etc. So one of the problems with the American flag statutes that say you cannot regulate display of the American flag, doesn't that mean if we are compelled to allow display of the American flag, I have to allow display of other flags? I think it does. I think it does. I think it opens the door. Now, there are lawyers who disagree with me, but I think it does. And once you have that, in my view, you can't regulate content. So if people have a Black Lives Matter banner that fits the time, place, and manner display, or a sign that fits the time, place, and manner display of other signs, my view is you cannot regulate the content. So as we've talked about in the past, I've had cases where people have torn down the Israeli flag off people's balconies. I've had that case. I've had people tear down the flag of, I think it was Libya. I think someone tore that flag off of somebody's balcony. I don't particularly know the politics behind that, but people shouldn't be tearing down people's flag based on the content. Even though some of the flags that I've run into have had hateful content, right? So people say idiotic things through signs and through flags at times. But the point I guess I'm making is the content shouldn't be regulated. It should be time, place, and manner. When you do it, where you do it, and how you do it. So go ahead, Mike.
All right, the next question here says, can the association invite the current mayor to give an update on the township at the next association open meeting? Mayor's up for re-election. Can the club in the community invite the mayor? Both would be just for the residents only, not the public. So we have this come up fairly regularly with police officers or somebody, a township administrator, coming to an open meeting and giving the update. You know, the new Wawa opens up down the road. We'll let you know what's going on, as well as for neighborhood watch, that kind of thing. It's certainly permissible to have the mayor come. I think the question becomes if in an election year, the mayor starts giving the pitch, right, to the community. And now the next thing that comes up is a phone call from another candidate running for mayor saying, hey, I want an opportunity now to use your clubhouse to speak to your residents. And I think that's where it can get a little sticky. Fran, I don't know if you have thoughts on that. If the association would then be more or less compelled to allow the other candidates to come and speak as well.
I mean, I think yes. I think Mike's point is well taken, that they would be, I think, compelled to allow the other candidate to come in. I don't think you're compelled, though, to invite the public, right? So it should be limited to members if you're going to go down that road. We do have associations that, as a matter of practice, have mayoral candidates or township committee candidates, or like Mike said, officer friendly from the town come in and talk about security, things like that. And that's a beautiful thing. That's great. You want township officials, you want state officials. Senator Singer used to come in and speak to some of the communities I work with, and Senator Singer did a great job talking to communities, and he really tried to foster relationships with various communities. So I'm not suggesting that you ban politicians per se from coming in and speaking at your communities. The issue is, though, that, as Mike said, generally speaking, if one side of the aisle can speak in your community, generally you cannot prohibit the other side of the aisle from speaking in your community. So that's a risk there. Let's see, can the association ban all signs, including congratulations to graduates, etc., of the local high school? No. And that's Twin Rivers. We're back at Twin Rivers, right? You can't just silence you know, the Supreme Court in Twin Rivers said, Twin Rivers won the case, right, in terms of allow their signage rules allowed enough in the court's opinion in terms of free speech. But I think the Twin Rivers court would say, no, as long as it meets the time, place, and manner, it's 3 feet by 3 feet or what have you, they can say happy graduation, congratulations to Mary Jane for graduating from you know, Trenton High or what have you. I think that's perfectly fine. You don't want to get into judging the content. Go ahead, Mike.
All right, yeah, the next question says, do you recommend setting a rule before you have the issue of size and quantity and location? And that's from Kathy. Thank you, Kathy. Yes. So if your community does not have a sign and flag resolution in place, the answer is you should put one in place. This way we have something to go back on. And it's going to state that all of our regulations are content neutral. Again, different time frames for different sporting events and elections and whatnot. I've had some boards say, hey, listen, we want to have the political signs no larger than, you know, 14 inches by 13 inches. But the reality is they're all 24 by 20 inches. So, you know, by putting in a rule, you're essentially making it impossible for people to put their political signs out when they're all the standard size. I don't think that would be permissible. But yeah, you should absolutely have a policy in place if you do not have one.
So Jeff says, hey, the U.S. government protects the flying of the American flag. Can an older version of the American flag be flown with the same protection? So the right answer right now is I don't know. The American flag is the American flag, though. There's nothing else like the American flag, right? So the American flag is the official American flag. However, Jeff, the statutes, my recollection at the top of my head, I haven't looked at it in a while, generally, I think also protect branches of the service flags, right? So Air Force, Marines, National Guard, Army, etc. Those flags are also protected under many statutes. So again, Jeff, you got to be really careful. So we have associations that actually acknowledge, whether right or wrong, the old kind of the flag from the revolutionary days, right, with the circle, the 13 original colonies. So I've never seen anyone try and pursue that being taken down, but so I've never run into it. I would just, again, I would get on the phone if an association member wants to try and have someone take it down. The big case, and we've talked about this in the past, that I got involved in, actually triggered this flag issue and the statute was the POW MIA flag, the black flag with the POW MIA symbol on it. And it was an unfortunate case, but it was people who really looked at the world from different generations and different approaches to the world. So what about contractor signs? Mike, you could take the one before that. Someone says she loves Donald Trump and why do I? No, I'm kidding. No. So what about contractor signs? The contractor signs, I would say you are probably safe prohibiting them, although they could be tested. As I said, the courts in New Jersey and even at the federal level often don't give what they would call commercial speech the same level of protection as political and religious speech. And I think that you could regulate them much more stringently. It just really depends whether you think it's worth the fight. I don't know any association homeowners that would pursue that, but you may get a vendor try to pursue it, right? So you may get a vendor that says, hey, I'm doing dryer vent cleaning, and Mrs. Jones said I could put Fran's dryer vent cleaning sign in the planting bed, right? And then the association comes around and says, no, Fran McGovern, that's commercial speech, it's got to go. And I, as the vendor, sue the association saying I had the unit owner's permission, not only are you infringing on her rights, through her, I have certain rights. As I said, though, the courts are not super big on that type of speech. So I think if you really wanted to regulate it, you could, if it was a problem for your community. But it really depends if you want to go down that road with respect to a fight. Go ahead, Mike.
All right, yeah, the one that we just jumped over said, if a sign just says Trump and not vote for Trump, can the sign stay up as long as someone wishes? I think this goes back to what we were talking about before, which is it's really unclear. It's more like a declaration of this is the type of person I am versus true political speech. But I think the lines get pretty fuzzy on that.
It does.
I I think your best bet would be pursuing the content neutral time, place, manner, right? So perhaps maybe the size of this, they've got one of those monster 5 or 6 foot signs. Maybe that wouldn't be permissible. But I think you're probably going to end up permitting the person to keep the sign up as long as it fits into the parameters. That's my guess.
Okay. What about a master association's failure to post a 3x3 predatory towing act sign at all entrances to the community but tows from a private street marked no parking? So Jeff, I think you're going to get jammed up on that if you don't have the proper signage under the predatory towing act. Yeah, I think that's just going to happen. What if the association's covenants prohibit signs? So this is always a good question, right? The board members will say, well, the governing documents clearly say X. Generally speaking, not always, but generally speaking, state and federal law will trump the association's governing document. Plain and simple. And the biggest issue, everyone's going to scream when I say this, is emotional support animals. So they'll say, I live in a pet-free building where the governing documents say there shall be no pets, no animals whatsoever. Fran McGovern, why are you telling me that Mrs. Jones gets to have her cockapoo or what have you? And the Federal Fair Housing Act trumps your governing documents no matter what. The other big example of this, you don't see it much anymore, was associations had rights of first refusal in their governing documents, which said the association can buy back the unit if it decides to do so once somebody is under contract of sale. And that is a void provision. It's presumptively void because it was used for racial discrimination purposes. So someone would go and try and buy a house in a community, and the association would say, no, under the governing documents, we're going to buy that back. And by the way, we have a right of first refusal under Article 6, Section 7 of the Master Deed. And that's presumptively invalid. I mean, there are certain exceptions to that, but generally speaking, you'd have to overcome the presumption of invalidity. Not me or any association, TMC managers, Twin Rivers Trust did it to a tenant. Oh, okay. So did it to a tenant. I'm missing that a little bit there, Jeff. So I don't know how I can follow up on that one. I don't know. So that was the last question. I think, Mike, did you have anything else?
I did not. Nope. That's all I had to.
All right. And if not anything else, so it is so nice to see the sun. I hope the lawns and everything dries out a little bit so that the managers can stop worrying about roof leaks and clogged pipes and muddy swales. And then the landscaper is turning his deck mowers around in front of my house, and I have tire tread marks. Why do they cut the grass in the mud? So I hope they are not out there cutting your grass in the mud or putting runts at your front lawn, because that is a mess. I hope your landscapers are treating you well, and you have a great, great weekend.